to prevent enforced disappearances. You reply to paragraph 18 in the list of issues that there is not any provision of domestic law explicitly prohibiting the expulsion, return, surrender or extradition of a person to another state where there are substantial grounds for believing that the person would be in danger of being subjected to enforced disappearance. And there are no specific mechanisms and criteria applied. Now, on non-refoulement, the Article 16 in the Convention. Please, can you provide information on whether an appeal may be lodged against a decision authorizing expulsion, return, surrender, or extradition, and whether such an appeal has a suspensive effect? You also state under 38C in your report that you may not accept diplomatic assurances when there is a risk that a person concerned may be subject to enforced disappearance. So this is a very welcome statement, I have to say. There are reports that Cambodia is colluding with other governments to return wanted individuals without due process. The regional governments fail to adequately investigate possible cases of enforced disappearances, including cases of cross-border disappearances. How do you reflect on these cross-border disappearances between Cambodia and other countries in the greater Mekong region? Could you please also explain the specific process and procedures observed to realize mutual legal assistance and international cooperation between countries in the investigation and prosecution of cases of cross-border disappearances? And now I have questions on enforced disappearance in the context of trafficking in persons and migration. So many Cambodians have become victims of trafficking in human beings into the sex and entertainment industry as well as brick kilns. Cambodia is also being used as a transit point to exploit victims from other countries to trafficking elsewhere in Asia. The Special Rapporteur on Cambodia underlined in 2023 report the importance to effectively implement the plan put forward by the National Committee for Countering Trafficking. Equally, there is an urgent need for establishing accessible mechanisms and rights-based processes to identify victims of trafficking. Already in the UPR 2019, it was recommended to reinforce judicial mechanisms to fight human trafficking and to legally prohibit the child sex trade in the context of the new National Action Plan for the Elimination of Illegal Trafficking and Smuggling in Human Beings, the exploitation of workers and sexual exploitation. So could you be more specific on what you have done concretely in preventing victims of human trafficking from becoming victims of enforced disappearance? And also, can you tell us what are the results of the implementation of the National Plan of Action to counter trafficking, which was in the time 2019 to 2023? And is there any data in the sentencing of traffickers? Cambodians, being migrants abroad, can also rely on the protection of the Convention Against Enforced Disappearance. Our committee has recently adopted a general comment on enforced disappearance in the context of migration that specifically outlines policies to protect migrants in countries of origin, in transit and receiving countries from becoming victims of enforced disappearance. Please inform us about your policies in advancing human rights-based migration processes, and please detail the measures taken to prevent the disappearance of migrants, as well as to search, investigate, and provide support services to migrants and their relatives in the event of disappearance. Now, on secret detention and fundamental legal safeguards prohibition against secret detention from Article 17. What measures have been taken to guarantee the effective implementation of fundamental legal safeguards for persons deprived of their liberty, including the rights to be informed in the charges against them, to have access to a lawyer of their own choice, and to notify a person of their preference of their detention? Registers of persons deprived of liberty. The Special Rapporteur on Cambodia, in its recent report from 2023, asks for maximizing access to physical and legal protection, tracking and tracing consistently the well-being of detainees in prisons and closed institutions, and use leverage to promote catalytic improvements. Please explain what have you done and undertaken specifically to inform and register properly on persons deprived of liberty in order to prevent them from enforced disappearance. Concerning places where persons are deprived of liberty, what are the elements listed in the Article 17.3 of the Convention that are required to record? Is the information contained in Article 73 of the Convention available when it refers to military detention facilities or immigration detention facilities? Please explain the measures taken to ensure that the registers are completed as soon as a person is deprived of liberty and are updated as necessary. Access to information by persons with legitimate interest. In Article 98 of the Code of Criminal Procedures from Cambodia, it stipulates that only after a period of 24 hours from the beginning of the police custody has expired, the detainee may request to speak with a lawyer or other person in his or her choice. In this context, how do you ensure a prompt and easy access to at least the information listed in Article 18.1 of our Convention? Now, my questions on training in human rights, particularly training on the provisions of the Convention. In your report in Article 23 and under paragraph 70, you report on training programs of judges and so on. And please specify in which form our Convention and the commitments made following the ratification of this Convention have been part of those trainings, and in particular of what you say the lessons learned in international human rights law. Please also explain specifically where and how enforced disappearance has been integrated in the training programs of public officials. You respond to it in the list of issues, in your response to the list of issues in paragraph 65, if you could be more specific on this. And also, going back to the discussion we had yesterday on an independent crime of enforced disappearance. I think the training would benefit enough or would enrich the training if you have a very clear independent crime of enforced disappearance. So that is very critical and enables the authorities and the staff in charge, I think, to understand really the specific nature of the offense, which otherwise is very complicated. Now back to still under the training in human rights. The Special Rapporteur on Cambodia, in its recent report from 2003, makes recommendations to the next generation of leaders to offer capacity building to other countries where the country can provide assistance with added value. And I think you, head of the delegation, in your opening remarks, you refer to the experience with the chambers of the Khmer Rouge crimes and so on. And now in our issue on enforced disappearance, your country, Cambodia, is the only country within ASEAN so far that has ratified the convention. So have you considered to reach out to ASEAN member states to win their support for ratification on the convention and for jointly fighting enforced disappearance in the region? Would you appreciate assistance by the Office of the High Commissioner or other entities working on the elimination of enforced disappearance in the ASEAN region? And are you interested also to intensify the cooperation with the Office of the High Commissioner and with our committee internally, for example, in implementing specifically tailored training programs within your country and for the civil servants and other entities you have? Okay, now I have time. Yeah, we have time, I think. Okay, sorry, I made a mistake to remind you of the time. So, definition of victim and the right to truth and to receive reparation and prompt, fair and adequate compensation. Could you inform whether there is an explicit provision to recognize the right of any victim to have access to the truth in accordance with Article 24(2) of the Convention? Please describe the steps taken to design and implement a system of full reparation, ensuring all the forms of reparation enumerated in Article 24(5) of the Convention. Then on the legal situation of disappeared persons whose fate has not been clarified and that of their relatives. According to Article 41 of the Civil Code, in case of disappeared persons whose fate is unknown, for 5 years, whether an absentee is alive or dead, the court may, upon the petition of a relative or a person with legal interest, make a judicial declaration of disappearance. Please explain how domestic legislation on this matter take into account of vulnerability in which enforced disappearance places the families of disappeared persons. And now I think my co-rapporteur can continue.
Thank you, Chair. Thank you, Chair. Greetings to the distinguished delegation of Cambodia. I will continue this second part of the dialogue where my co-rapporteur, my colleague, left, and I will be addressing Article 25. Article 25 is a wide article which provides for different measures that the state should take in order to live up and to fulfill the implementation of the Convention. And the first one regards the criminal legislation in your country. We have asked you in the list of issues if there is any specific provision to punish the wrongful removal of children, and we understand, we take note that your reply is no, there is no specific article. Anyway, you have informed us, and we have taken note about different articles in your criminal legislation, like I'm mentioning now Article 327 of the Criminal Code and Article 10 on the law of suppression of human trafficking on sexual exploitation. My question to you would be how these two pieces of legislation can foresee and cover different aspects of wrongful removal of children. And there are three in paragraph A of the article, which are clear enough. Wrongful removal of children can happen if they are themselves subject of enforced disappearance. The second category are children whose father, mother, or legal guardian is subject to enforced disappearance. And third are children who are born during the captivity of their mother. And I think that the Convention reflects all these situations because they come from, unfortunately, lived situation in different parts of the world. And to protect children which are a special category, which may be under particular vulnerable situation, the fathers of the Convention have decided to have this special protection for children. So my question would be, how would the existing legislation would cover these situations? I hope you have not faced them, but still the Convention has a name, which is a prevention. So let's see it also in this angle, not only of what is your experience, but what will be the best choice and solution to find and to give proper protection and proper prevention to every child in your country. The second element of the Article 25 is connected with the falsification, concealment, and destruction of documents that attest the true identity of the child. And still, in this element, I've taken note that there is an Article 333 of your criminal code which provides for that. But still, I would like also to see a reaction from your side, how it fully covers the specific situation of enforced disappearances. During information that you have provided in the report, we learned that there is a national policy for the child protection system, which goes until the year 2029. And there is also a child protection law draft, which is underway. I would like to have more information, if you can, please, about the progress of the discussion of this law, and if there is any kind of initiative that this specific situation provided in Article 25 of our Convention may be included also in this new draft law. Another question that I will have also in that regard would be if there is any case when you have asked or been asked by any other state party to provide assistance in searching and identifying or locating the children which are subject of enforced disappearance or victim of enforced disappearance in the three categories that I mentioned before. If there is any particular case, would be very interested to know. And the last element or topic, which is quite important as well, relates to the phenomena of illegal intercountry adoptions. Unfortunately, when I've read about the situation in the country, I've learned that there has been a problem with this phenomena, especially starting from early years of 1979, and then back in 2000, there are several countries which have banned adoption from Cambodia. We are speaking about international adoption on basis or on claims that Cambodia does not fulfill conditions for international child protection. I would like to hear your opinion on that, how the situation remains on that regard. Is the legal system in your country, say, fully in compliance with international standards on international adoptions? And I need also to put to your attention the fact that on December 2022, the committee has approved or has adopted, together with other stakeholders, not only our committee, but a lot of other actors has joined. That means that it has really an important support, this kind of initiative. The joint statement on illegal intercountry adoption. While we state that the states parties have a duty to prevent illegal intercountry adoption by promulgating and implementing laws, policies, and other measures that may be necessary concerning the adoption process. Could you inform us on the measures taken by Cambodia to address the issue of illegal intercountry adoptions? Does the domestic legislation prohibit illegal intercountry adoption as a continuing offense under criminal law? Can you inform us on the measures necessary to ensure that all cases of illegal intercountry adoptions are investigated in a complete, impartial, diligent and effective manner, even in the absence of a formal complaint? Can you please provide to us any update statistical information on illegal intercountry adoptions, including the dates of adoptions and the numbers of persons whose true identity has been reestablished? And this is also linked with the question that we usually pose if the country has a system of annulling adoptions which originate from enforced disappearance. I read in your replies that yes, annulment of adoption can happen, and it is decided by the court, but I would like to, if you can please, to explain a little bit more. The court decides in which legal basis, or it's the subjective interpretation of the judge on annulment of adoptions, because this is very much linked with this specific and very harmful and painful, I should say, phenomena of illegal intercountry adoption. And I thank you for the replies that you may provide to our questions.
Merci.
Thank you very much, Madam Janina. I now look to my other colleagues to see whether or not they would have any questions to ask the delegation at this point in time. And if that's not the case, we will take a 15-minute break to allow the delegation to organise their answers. So, there being no questions, in addition to the rapporteurs, we will see you back in the room at around 10:40. Thank you.